Thank you to our sponsors. Platinum sponsor, Gravity Forms. Build accessible, powerful WordPress forms with Gravity Forms. Flexible tools for creators, developers, and teams of all sizes. Platinum sponsor, WP Engine. WP Engine provides the most relied upon and trusted WordPress products for businesses, brands, and agencies of all sizes. Platinum sponsor, Woo. WooCommerce is the open-source e-commerce platform built on WordPress, helping merchants worldwide sell, manage, and grow their businesses. Gold sponsors, Ally Web Accessibility. Equalize Digital, websites for everyone. GoDaddy, Green Geeks Web Hosting, Yoast. Silver sponsors, Aardvark, Code Geek, Your Vision, Our Talent, One Team, Kinetic Iris, Kinsta, Pressable, Second Melody. Bronze sponsors, Nine Planets Hosting, Engage, Draw Attention, Multidots, NerdPress, OSAM Studio, AusEY, Australian Web Accessibility Initiative, Progress Planner, Quality Logic, Sharp, Simply Schedule Appointments, SiteGround, Stellar WP, Termageddon, Web Yes.
Welcome to WordPress Accessibility Day 2025. My name is Madeline Inti, and I'm the Acting Secretary with Google Developer Group Sukra. Thank you for joining us for Accessibility Lawsuits in WordPress, the violations every business needs to know with Vanessa Tillmans. Vanessa Tillmans is the founder of Porpoise, a digital accessibility firm built to protect businesses from costly lawsuits and lead the next generation of web compliance. With multiple certifications and deep legal insights, she helps companies move beyond surface-level fixes into true digital protection. Vanessa focuses on what impacts thousands of businesses each year, the high-risk accessibility violations that lead to litigation. Her work combines strategy, ethics, and precision to help organizations safeguard what they've built and reach the 1.3 billion people worldwide living with disabilities. Please feel free to add your questions in the Zoom Q&A section, and we will answer them at the end of the session. Use the chat to connect with other attendees.
Hi, everyone. I'm so glad you're here today. The title of my talk is Accessibility Lawsuits and WordPress, the violations every business needs to know. Here's where we're headed today. We'll start with a little bit about me and my company, so you know the perspective I'm coming from. Then we'll zoom out for a legal overview, what the current landscape looks like, and how accessibility lawsuits actually work. From there, we'll dig into how websites are being targeted and the impact on businesses, especially when those lawsuits hit WordPress sites. Next, we'll look closely at the violations that come up again and again in these cases. I'll share some thoughts on what you can do and also what you can't do to manage your risk. And finally, we'll wrap up by looking at the future of digital accessibility law with both federal and state actions that are shaping what comes next. By the end, my goal is that you'll walk away with a clear understanding of why these lawsuits keep happening, what's driving them, and the practical steps you can take to stay ahead. My name is Vanessa Tillmans, and I'm the founder of Porpoise, a company I started with one mission: to make the web more accessible and protect businesses. I was working as a freelance web developer when I first encountered digital accessibility, and that happened through a lawsuit. What surprised me wasn't just that a lawsuit was filed, but who was sued and why. That experience completely changed my perspective on websites and showed me how serious and widespread this issue really is. Before launching my company, I earned certifications in accessibility from the International Association of Accessibility Professionals and in website accessibility testing from the U.S. Department of Homeland Security. Because I've always been fascinated by the legal side of things, I began following accessibility lawsuits closely, and that perspective shapes how I approach my work today. It's why I stay tuned in to the legal landscape and why I'm here sharing these insights with you. Quick disclaimer, I'm not a lawyer, so while this talk focuses on lawsuits, I can't keep you out of court, but I can help you reduce your risk so you're never in that position. Also, this slide does have some meaningful images. It shows a photo of me, along with the logos for the International Association of Accessibility Professionals and the U.S. Department of Homeland Security. So let's get right into it. In 1990, on the South Lawn of the White House, the Americans with Disabilities Act was signed into law. This wasn't just another piece of legislation. The ADA was the first comprehensive civil rights law for people with disabilities anywhere in the world. It outlawed discrimination in employment, transportation, public accommodations, communications, and access to government programs and services. Back in 1990, however, we were on the brink of a transformation that would change everything: the internet. No one could have imagined it would soon shape how we shop, how we learn, and how we connect. So the ADA, groundbreaking as it was, never even mentioned websites or apps, and that gap is what opened the door to lawsuits. It started with the Target case in 2006. The National Federation of the Blind sued Target because blind customers couldn't shop independently on Target's website. Think about this: images with no alt text, menus that couldn't be navigated with a keyboard, and checkout forms that literally prevented some people from being able to make a purchase. Here's why this case mattered. It was the first major class action digital accessibility lawsuit. The court ruled the ADA does apply online when a site is tied to a physical store. Target settled in 2008. They paid $6 million, committed to follow the Web Content Accessibility Guidelines, and agreed to years of monitoring by the National Federation of the Blind. For the first time, a retailer was legally forced to fix its website. This wasn't just a slap on the wrist. This case set the stage for everything that came after. Fast forward to 2019, Domino's Pizza didn't just face a lawsuit, they fought it tooth and nail for 6 years. A blind customer couldn't order food on their website or app with a screen reader. Rather than addressing the issue directly, Domino's chose to challenge the legal interpretation. They argued that the ADA never said it applied to websites, and even if it did, it didn't say how to make a site compliant. So they spent years in court filing appeals and racking up what had to have been a massive legal bill. The Ninth Circuit ruled against Domino's. They appealed to the Supreme Court, but the court refused to even hear the case, and that silence spoke volumes. The Domino's decision confirmed that the ADA extends to websites and apps. In the years that followed, digital accessibility lawsuits rose sharply as courts and plaintiffs reinforced this interpretation across the country. And then in 2024, 34 years after the ADA first became law, it was finally updated to address websites and apps. The U.S. Department of Justice updated the ADA to explicitly require public entities, not just state and local governments, but also hospitals, schools, police departments, libraries, transit systems, to make their websites and apps accessible with a firm deadline. They also said how you do this: by complying with the Web Content Accessibility Guidelines, or WCAG for short. But this update only applies to public entities. Private businesses aren't covered, at least not yet. And that gap is exactly why lawsuits against private businesses keep piling up. While Congress debates and agencies write rules, the courts are where these battles are being fought. And that means one thing: if you want to understand accessibility lawsuits, you have to understand the legal foundation behind them. Right now, web accessibility lawsuits are at an all-time high across the U.S., with over 5,000 lawsuits expected to be filed this year. That makes understanding the legal foundation critical, because without it, you can't understand why some lawsuits stick and others get tossed out. For any accessibility lawsuit to move forward in federal court, the plaintiff has to establish standing under Article 3 of the Constitution. Article 3 is what gives federal courts the power to hear cases and controversies. That phrase, cases and controversies, is key. It means courts can't just weigh in on abstract disagreements or hypotheticals. They can only decide disputes where there's an actual live conflict that affects someone directly. That's where standing comes in. Standing is the legal gatekeeper for who gets to bring a case. If a plaintiff can't show they've been directly affected, the court likely won't hear the case. To establish standing, plaintiffs must prove 3 things. The first is actual or imminent harm. They must show that they personally suffered concrete harm, not just annoyance that a website was inconvenient or hard to use. Next is causation. There has to be a direct link between their harm and the barriers on the website. Likelihood of future harm is also a requirement. They must prove they're likely to encounter those same barriers again if they return. And courts often look for one more element: intent to purchase or return. Just browsing a site isn't enough. Plaintiffs need to show genuine interest, that they wanted to buy something, sign up, or use the services. Without that, courts might dismiss the case. This is what's known as the proof of harm requirement. Courts have increasingly ruled that simply saying I couldn't access the website isn't enough. There has to be real-world harm behind it. For example, in one case, a blind plaintiff sued a university over their inaccessible website. The court dismissed it because he wasn't a student there and he didn't have any intent to enroll. No harm, no standing, and no standing means no court case. So the big takeaway here is this: not every lawsuit makes it through the courthouse doors. Plaintiffs need to satisfy these conditions before the court will consider the claim. But here's the key: the bar isn't as high as you might think. If someone can show they genuinely wanted to access your website, to read about your company, make a purchase, schedule a service, sign up for a newsletter, or use your app, and they were blocked by accessibility barriers, that's often enough for standing. Standing is what gives a lawsuit real traction. So while some cases get tossed, plenty move forward. That's why businesses can't afford to ignore accessibility, because when plaintiffs can show clear intent and harm, courts are likely to allow the case to proceed. In short, standing isn't automatic, it's built on evidence. But when that evidence exists, accessibility barriers become a strong legal risk for businesses. So now that we've talked about standing, let's move to Title III of the ADA, the part of the law that covers public accommodations. In simple terms, Title III applies to businesses and nonprofits that serve the public: hotels, restaurants, stores, theaters, hospitals, schools, museums, and other places open to the public. If it serves the public, it's a public accommodation. But here's the big question: do websites count as public accommodations? Some courts say yes, but only if the website is directly tied to a physical business. That's called the nexus requirement. Nexus just means a connection. So if a blind customer can't order from an online store that also has a physical location, that's a nexus case. The problem is courts don't all agree. The U.S. is divided into 13 federal circuits, each with its own court of appeals. That's the level just below the Supreme Court. These circuits cover different regions of the country, and they don't always interpret the law the same way. Here's how it works. Cases usually start in a district court, where a judge hears the case and makes a ruling. If one side disagrees, they can appeal to the circuit court. Circuit courts don't hold new trials. Instead, a panel of judges reviews whether the law was applied correctly. And once they decide, that ruling becomes binding precedent for every state in that circuit. So when we talk about the Ninth Circuit or the Third Circuit, we're really talking about appellate courts that shape how the ADA is applied across entire regions of the country. For example, the Ninth Circuit, which covers states like California, Arizona, and Washington, has often ruled that websites themselves can qualify as public accommodations. We saw this in the Domino's case. A blind customer couldn't order from their website or app. The district court dismissed the case, saying the ADA didn't apply, but when it was appealed, the Ninth Circuit disagreed, ruling that digital experiences connected to physical businesses are covered under the ADA. Domino's appealed to the Supreme Court, but the court declined to hear it, letting the Ninth Circuit's decision stand. That's the power of the circuits. Their rulings ripple across entire regions, and unless the Supreme Court steps in, they set the law of the land. So whether your website counts as a public accommodation can depend on where the lawsuit is filed. In some circuits, a website may fall under ADA Title III. In others, it might not. That uncertainty has fueled thousands of lawsuits because plaintiffs often file in courts most favorable to accessibility claims. I don't think this uncertainty will last forever, though. Right now, Congress is considering a bill that would establish clear nationwide rules for digital accessibility. Later in this talk, I'll walk you through what that bill says and why it could rewrite the rules for every business in America. Now let's look at where these lawsuits are actually landing. In 2023, nearly 4,000 businesses were sued for inaccessible websites, and more than half of those lawsuits targeted just two platforms, Shopify and WordPress. Shopify topped the list with 1,378 lawsuits. That's over a third of all cases. WordPress came next with 700 lawsuits, nearly 1 in 5. Together, they accounted for over half of all web accessibility lawsuits that year. That's not coincidence, it's a clear pattern. Plaintiffs are focusing on e-commerce, where barriers are easier to prove. Shopify and WordPress dominate that space, powering millions of online stores. Because these websites are often template-driven and plugin heavy, they're prone to accessibility issues, making them frequent legal targets. E-commerce sites are especially vulnerable because the harm is concrete. If a customer can't complete a purchase, that's a measurable denial of access. So if your business runs on Shopify or WordPress, you're operating on the platforms most often named in lawsuits as they're used by so many businesses in e-commerce. And remember, e-commerce isn't just a convenience, it's today's main entry point for shopping. When access is blocked, it's not just a compliance problem, it's a barrier to participation in the modern marketplace. These lawsuits have been concentrated in specific high-risk industries. In 2023, 10 industries made up over 93% of all web accessibility lawsuits. Leading the list was fashion and retail, with over 1,100 cases, nearly 1 in 3. E-commerce has become the front line of digital accessibility litigation. Next, restaurants and food services hit with 885 lawsuits, often due to menus and ordering systems incompatible with screen readers. Healthcare, home decor, and fitness also appear frequently, industries where accessibility is critical for equal access. And despite common assumptions, small and mid-sized businesses are most often targeted, local shops, restaurants, and clinics that may not realize the ADA applies to their websites and apps. For many, the first notice of noncompliance comes with a lawsuit, bringing legal fees, settlements, and reputational harm. If you operate in these industries, especially retail or restaurants, you're in the spotlight. Now is the time to make your site accessible before a lawsuit makes the decision for you. And as if a lawsuit weren't enough, it can actually get worse. What many businesses don't realize is that the U.S. Department of Justice can step in. They're the federal agency responsible for enforcing the ADA. When that happens, it's not just a court order to fix your website. It becomes a consent decree, a multi-year agreement that goes far beyond basic WCAG compliance. These decrees often require complete website overhauls, hiring dedicated accessibility staff, regular audits and reports, mandatory staff training, testing by people with disabilities, and on and on. Each of these requirements carries significant cost, often adding up to hundreds of thousands of dollars. Once the DOJ steps in, they set the terms and conditions. You're required to meet every demand on their schedule. But when you act proactively, you stay in control. You decide the timeline, the priorities, and how to build accessibility in a way that fits your business and budget. The goal isn't to avoid accessibility, it's to protect your business by doing it on your own terms before someone else decides for you. Let's talk about accessibility widgets, those little icons that pop up in the corner of a website and promise to help with ADA compliance. It sounds convenient, right? Who wouldn't want an easy fix for something this complicated? But here's what the data shows. In 2023, nearly 1 in 4 ADA website lawsuits were filed against sites that already had a widget installed. These businesses invested in tools marketed to improve accessibility, yet still faced legal action. The 3 most frequently named widget providers in those lawsuits were Accessibe, appearing in 348 cases, Userway, 246, and AudioEye, 72 cases. In total, there were 929 lawsuits involving sites using accessibility widgets that year. So if these tools are intended to help, why are so many sites using them still being sued? Because widgets don't fix underlying accessibility issues. They don't repair broken code, label unlabeled buttons, or ensure proper navigation. They're applied as an overlay, sitting on top of existing barriers rather than removing them. Courts and plaintiff law firms are increasingly focusing on this distinction. Under WCAG, accessibility must be built into the website by default, not added through user-activated tools. For example, a link has to be distinguishable from regular text without relying on color alone. That's the standard. That's what compliance requires. Shifting that burden onto the user, expecting them to find a widget, open it, and toggle on a setting just to read your content, That does not align with WCAG requirements. In fact, research has found that widgets can interfere with assistive technologies. In particular, some screen reader users have reported that widgets disrupt navigation, prevent form submission, or override custom settings. A 2024 master's thesis examining Accessibility, UserWay, and AudioEye tested usability for participants with visual impairments. The study found no measurable improvement in accessibility, and in some cases, participants reported a worse experience once they realized a widget was there. Even the National Federation of the Blind has spoken out against widgets, saying they undermine accessibility standards and create barriers for blind users. So accessibility can't be achieved through a widget, and relying on one can actually increase your risk of a lawsuit. Legal compliance means fixing the accessibility barriers in your code, your design, and your content. That's the only approach that truly works. Now let's take this one step further, because it's not just businesses facing lawsuits. Some of the widget companies themselves are now under legal scrutiny. Take Accessibility. Their tool was marketed as a simple solution. Just install it and your site becomes ADA compliant. But when lawsuits continued, a class action lawsuit was filed. In 2024, the Federal Trade Commission investigated and fined them $1 million over marketing practices related to ADA compliance claims. And now UserWay is in a similar situation, currently the subject of a class action lawsuit alleging that its marketing misled customers into believing their widget ensured compliance. Here's the bigger picture. So far, no widget company has demonstrated that their product alone can bring a site into full compliance with ADA or WCAG standards. Because accessibility can't be layered on, it has to be built in the code, in the content, and in the design. These cases underscore a critical legal truth. Compliance cannot be outsourced to a widget. Under the ADA and WCAG, accessibility must be inherent to the design and development, embedded in the site's code, and verified through testing, not applied retroactively through a third-party widget. Quick fixes may seem convenient, but they don't satisfy legal obligations or prevent liability. Accessibility isn't a feature you add, it's a legal requirement and a civil right that demands deliberate design, verification, and accountability. Now let's look at one of the most common violations cited in lawsuits, missing alt text. It's also one of the easiest to fix. Alt text, short for alternative text, is what a screen reader announces to describe an image. Without it, the image isn't communicated to the user at all. That means someone using a screen reader has no way of knowing what's there, whether it's a product photo, a chart, or a button. Here's where many people get confused. Not every image needs alt text. Under WCAG, only images that convey meaning or perform a function require it. Adding alt text to purely decorative images is actually a violation under WCAG. The W3C, the organization behind WCAG, has an excellent images tutorial that explains this in detail, covering every image type you'll find on a website and when alt text is or isn't required. It also walks through how to write clear, helpful alt text. Getting this right matters because cluttering someone's screen reader with unneeded descriptions makes navigation harder, not easier. On this slide, you'll see the alternative text field from the WordPress Media Library. When you upload an image, you'll also see a link below it. Learn how to describe the purpose of the image. That link takes you straight to the W3C guide. And now that we know e-commerce sites are the top targets for lawsuits, this violation makes perfect sense. Every product image and each variation of it needs accurate alt text. For example, imagine a store displaying a hat in 8 colors, where the brown and orange versions are 30% off, but that discount only appears in the image. Without alt text, a blind customer would never know that sale exists. That's not just an accessibility issue, it's a missed opportunity. When information like discounts or product details isn't conveyed to all customers, the business itself takes the hit, losing potential sales, trust, and opening the door to legal action. Next on this list, and one that can completely block access, is keyboard navigation barriers. Under WCAG, anything a user can do with a mouse must also be possible with a keyboard. That means being able to tap through menus, open drop-downs, fill out forms, click buttons, watch videos, all without ever touching a mouse. But when this breaks, it's not just inconvenient, it can make your site unusable. Imagine this on an e-commerce site. A customer is tabbing through a product page, ready to add an item to their cart, but when they reach the Add to Cart button, it's not focusable. Or when they open a size selector for the pants they want and they're unable to move forward or exit out of it. That's called a keyboard trap, and it's one of the most damaging accessibility violations you can have. For users who rely on keyboards, including people with motor disabilities, blind users with screen readers, and many others, if the keyboard doesn't work, the website doesn't work. And here's the challenge. In WordPress, barriers can come from themes, plugins, page builders, even a marketing pop-up. You might have an accessible menu, but a plugin could introduce WCAG violations. That's why you have to test it manually. Put the mouse aside and use only your keyboard. Can you reach every link, button, and form field? Can you close a pop-up? Can you complete a checkout? If you can't, neither can your customers who depend on keyboard access. And in e-commerce, that means lost sales, frustrated users, and potential lawsuits. Because it's not just a code issue, it's a barrier that stops someone from buying your product. Now let's talk about inaccessible forms, one of the most common and most damaging barriers online. Forms power everything we do on the web. They're how customers check out, subscribe to a newsletter, create an account, or request help. In e-commerce, a single inaccessible form can block an entire transaction. Here's what happens when accessibility is missing. If a field has no programmatic label, screen reader users don't know what to enter. If error messages aren't linked to the correct field, they can't tell what needs fixing. If the form can't be completed with a keyboard, many users can't submit it at all. Accessibility in forms means that every input must have a proper label, and placeholders do not count as labels. Required fields must be clearly identified. Errors must be announced and associated with the correct field, describing what's wrong and what needs to be entered. The full form, from start to submit, must be operable with a keyboard alone, because when a form fails, it's not just a technical issue, it's a lost opportunity, a blocked purchase, a missed sign-up, or a denied application. Under the ADA and WCAG, these aren't just usability bugs, they're barriers to equal participation. So test every form on your site, whether it's a checkout page or a one-field newsletter sign-up. Ask yourself, can it be completed without a mouse? Can every user understand what's required and fix errors independently? If not, the form isn't just broken, it's excluding some people, and that's just the kind of violation that lands in lawsuits. Next up is inaccessible videos, and this one carries major weight because video is one of the most powerful tools businesses use to communicate, to sell, to inspire, to connect. But when accessibility is missing, it becomes one of the most common and costly barriers cited in lawsuits. The first issue is missing captions. When captions are absent, deaf and hard of hearing users lose access to the spoken message, the dialogue, the instructions, maybe even the emotion that drives engagement. Captions aren't optional, they're required for equal access. The second barrier is no text descriptions. Think about short product clips, a model turning to show how a jacket fits, a demo showing how software looks, a close-up of fabric texture, any kind of video where there's no sound, no narration, just visuals. These need a text description because without it, blind users are excluded from the information that's being shown. In lawsuits, these videos are often cited because they deny equal access to product details and brand storytelling, key information that sighted users receive instantly. The fix is simple. Add captions to every video with spoken content, add text descriptions to videos without narration, so visuals are equally conveyed through words. Every clip tells a story. You just want to make sure everyone can get it. And let's look at one more, low color contrast. This one doesn't just affect people with low vision, it affects everyone. Think about when you've seen light gray text on a white background. That can be really hard to see for some users. I was just editing a video recently, and the control bar at the bottom was so faint it was almost invisible. That lack of contrast made the task harder, and on a website, that same issue can become a barrier. When the text blends into the background, people can't easily read your content, navigate your menus, or use your forms. And when that happens, users leave, or if they can't leave because they need to complete something, it becomes a source of frustration. You can absolutely design something beautiful and on brand. You just need to ensure your colors meet the contrast ratios that WCAG specifies. Often it's as simple as adjusting a hex code slightly to stay compliant while keeping your look consistent. And remember, low color contrast isn't just a design flaw, it's one of the most common issues cited in accessibility lawsuits. These 5 examples represent only a small portion of the violations repeatedly cited in accessibility litigation. Each constitutes a barrier that excludes users and creates measurable legal exposure for businesses. Addressing accessibility is not merely a best practice, it's a legal obligation and a critical safeguard for compliance, usability, and brand integrity. We've covered the law, the lawsuits, and the most common violations. Now it's time to bring it all together. Here's what you can do. Test your website thoroughly. You can't fix what you haven't identified. Automated scans are a helpful start, but they only catch a fraction of accessibility barriers. The issues that trigger lawsuits are often the ones those tools miss. Combine automated checks with manual testing to uncover the full picture, then remediate those issues. Involve disabled users. Hire people with disabilities to test your site. Screen reader users, keyboard only users, low vision users. Their feedback provides authentic, real world insights that mirror the experiences documented in lawsuits. There are helpful tools you can use in WordPress, like Joel Dolson's accessibility plugin and Equalize Digital's accessibility checker. These can help you identify and address barriers. And finally, follow the recognized legal standard. WCAG 2.1 Level AA is the technical standard currently in the ADA. Now, what you can't do. You can't assume your website is accessible just because your theme claims it is. Even accessibility-ready WordPress themes still require testing, and page builders can override that code, introducing new barriers. You can't treat accessibility as a one-time project. Every update to WordPress core, page builders, themes, or plugins can introduce new accessibility barriers. That's why ongoing testing is vital. In fact, DOJ settlement agreements often require businesses to test their websites every 6 months. And you can't rely on widgets. They don't bring your site into compliance and often create additional barriers. Compliance isn't static, it's maintained through consistent action. So after everything we've covered, the lawsuits, the rulings, the violations, the big question is, where is this all heading? In April 2024, the Department of Justice updated the ADA, requiring all public entities to make their websites and apps accessible. That's now a clear deadline and no gray area. But private businesses are still navigating a maze of lawsuits and unclear rules. That might soon change. In May 2025, a bipartisan group in Congress introduced H.R. 3417, the Websites and Software Applications Accessibility Act. It's still in committee, but if it passes, it will rewrite the rules for every business in America. This bill would cover public-facing websites and apps, including online-only businesses. It would close legal loopholes that have fueled confusion and litigation. It would establish clear nationwide standards aligned with WCAG, and it would require updates every 3 years so the law keeps pace with technology. For the first time, enforcement would be unified, shared between the Department of Justice and the Equal Employment Opportunity Commission, giving businesses a clear roadmap and a single standard to follow. But more than a regulatory shift, this marks a civil rights milestone. Because once this law passes, digital accessibility won't just be best practice. It will be recognized for what it truly is: a right to information, a right to participation, a right to access, and that's where the future is headed. While Congress continues to debate federal standards, some states have begun taking action on their own. targeting patterns of abusive website accessibility litigation that overwhelm small businesses with repetitive lawsuits. In 2023, Kansas became the first state to pass the Act Against Abusive Website Access Litigation. This law allows Kansas businesses or the Attorney General to sue the plaintiff or attorney when lawsuits are deemed predatory. Other states are now following Kansas's lead. In 2025, Illinois introduced the Stop Abusive Website Access Litigation Act, granting the Attorney General authority to bring civil actions against parties or firms that repeatedly file meritless website accessibility claims. These laws, however, do not block legitimate cases. They preserve the right of individuals with disabilities to pursue valid claims, but they aim to curb bad faith filings that do little to advance accessibility. Together, these state measures reflect a growing call for balance, ensuring access remains a civil right while protecting businesses from abuse of process. And as more states act, the pressure builds for a clear, unified federal standard, precisely what the Websites and Software Applications Accessibility Act seeks to establish. After all the lawsuits, laws, loopholes, and lessons, it comes down to one thing: make your website and app accessible, not out of fear of litigation, not as a checkbox for compliance, but because people depend on what you offer, and too many can't reach it if your site isn't accessible to them. Your digital presence is the front door to your business. If it's closed to some, it's closed to too many. Accessibility is the key that opens that door. So test thoroughly, remove barriers, and design with empathy, because accessibility is ongoing, a continual commitment to ensuring everyone can engage with what you've built. This is how we move from lawsuits to lasting impact. Thank you for spending this time with me. Accessibility is something I care deeply about, and I'm grateful for the chance to share why it matters. My hope is that today helped you see accessibility differently, not as a checklist, but as a bridge that connects people to what you've built. If you'd like to continue the conversation, whether it's exploring your own site, building a roadmap, or simply learning more, I'd love to hear from you. You can reach me at porpoise.com or connect with me on LinkedIn. Together, we can create a web that truly welcomes everyone. Thank you.
Yes, thank you very much, Vanessa Tillmans, for that presentation. And this is also to remind everyone that the Q&A section is live, so you can place in all your questions and Vanessa will answer them. So let me go to the Q&A section to see some questions that we can roll up. Okay, Vanessa, can you hear me?
Yes, I
You're
can hear
good?
you. Perfect. Yeah.
Great. So Bet Hannon is asking that does HR 3417 still allow for citizens to sue, or is all enforcement to move to DOJ?
That's a good question. So the current draft does include a private right of action allowing individuals to sue. Yeah, rather than shifting all of the enforcement to the DOJ.
All right, great. And well, this is an anonymous attendee, and he or she is asking that with the current administration, do you foresee less enforcement of the ADA, or do you have any fear that the current DOJ might use it as a tool to put more burden on some sites more than others, depending on their judgment?
Yeah, that's a good question. So there have been some changes in the current administration, right, that have affected web accessibility. So, I don't know what's going to happen per se with that. Less
Mhm.
enforcement of the ADA? I don't think so, because of the fact that Congress has introduced this bipartisan bill and people are talking about it. And, so Congress is addressing this issue, first of all. And secondly, the DOJ does have that deadline. So I don't see any less enforcement happening. But I do think that the current administration could be addressing some things that perhaps aren't being addressed yet.
Mm,
And so yeah, that's what I think for now. And what was the other part? Let's see. The DOJ might use it as a tool to put more burden on some sites.
yeah.
No, I don't think so. I think what it comes down to is really like what is the lawsuit saying, right? And what's the lawsuit saying about what the harm was to the plaintiff, and what is the DOJ going to do to get involved with that if they decide to get involved in that settlement? And so for some cases they do get involved, and for others they don't. And so I don't, they have to have the staff to be able to do that too. And so, as long as they've got enough bandwidth to handle those kinds of things, and I most certainly think they will, especially with the deadline.
All right. Another question goes, do accessibility laws impact your digital presence on social media graphics, blasted emails, or is it just the website?
That's a really good question. So, social media accessibility is a thing for public entities. So, government institutions and the like are supposed to start be working on that, and there is a deadline for them. And so, yes, social media graphics for sure are going to have to be accessible. But there are exceptions to that. And I did a blog, or not a blog post, a LinkedIn post a little while ago about that, what the exceptions are. Like if it's talking about a citywide something or other that happened in 2023, the city is
Mm-hmm.
not going to be required to go back and like put alt text on an image that old, so there will be exceptions in there, and there is a link from the DOJ with those exceptions. So I can look it up and send it to you guys afterwards if you want,
Sure.
but there is a link for that. Yeah.
Sure, thank you. And Anita Larson is asking, does any legal responsibility fall on the web developers themselves, or is it the responsibility of the entity or business?
Yeah, that's a really good question. So the answer is it can, right? So when a lawsuit is filed, it's the business that's sued, right? But the business can then turn around and sue the web developer or the web agency. And so, for
Mm-hmm.
sure, if a web agency gets sued by their client, that is an absolute thing that can happen. And they can accuse the agency of not having informed them or told them that this was a thing that they needed to do. So, when the lawsuit is filed against the business, it's the business that's sued. But then the business can turn around and sue the web developer or the agency that they hired.
Okay. And this is anonymous, is asking if you show you are making your website accessible, but you're not fully accessible, still working on it, can they still sue you? Sometime it takes time in making it accessible. So I was asking.
Yeah, that's a really good question. And so, one of the things that I didn't mention in the presentation, which is super important that everyone do, is have an accessibility statement on your website, because that gives people the ability to reach out to you and contact you if they run into a problem. In fact, when Nike was sued, that actually was mentioned in the lawsuit. The fact that there was not an accessibility statement on their website was in the lawsuit. So, and the reason that was in there is because that is the way that someone can reach out to you if they need help. So, yes, have an accessibility statement that says, we're working on it, right? We're working on it, we're doing the things, have a way for them to reach you either by phone or email or whatever. But then, you know, do be showing like active work. If 6 months passes and it's still in the same place it was 6 months prior, you know, that might not look so good, right? And if a year passes and that's too long. So you do want to be working especially on the what I would say are like the high priority things that get cited in lawsuits. So your critical user flows on your website, any place where a user can get to a form, they can make a purchase, they can sign up for something. Those are high priority user flows. You're going to want to check all those, test them, and fix them. So focus on the high priority things that are mentioned in lawsuits and then keep working from there. But absolutely, you can show that you're working on it by your accessibility statement. And if you do not have one on your website, just put it up there today. It's probably the best thing you can do legal wise.
Okay, and the last one, it was already answered in the chat box, but I would want to also read it out so everybody hears it. So, Taco asks on taylorswift.com, there's fine print text at the bottom of each page telling screen reader users to call a number if they run into problems with the website. Is this sufficient to comply with the ADA, or should they really make website accessible?
Yeah, that's a really good question too. And no, that does not make a site compliant with the ADA. because the ADA now has been updated, right? And it says that a site has to comply with WCAG. And so to comply with WCAG does not mean you put up a statement saying, call us if you have a problem. So under the ADA, businesses must provide people with disabilities equal access to the goods, services, and information they offer online. So equal access means being able to use the website independently without having to call a number for help. Absolutely have it in your accessibility statement for sure if you want to have a phone number on there, but at the very minimum, have an email address in there. But that does not make a website compliant. So hopefully Taylor Swift's working on that if she's not already, her and her team getting that site fixed, because they unfortunately are a target. Beyonce was sued, so celebrities do get sued over this. They have been. Jeffree Star websites was sued. Who else? Kim Kardashian. Yeah, so celebrities are a target. So they really should absolutely be doing things to fix their website for sure.
Okay, thank you very much,
Yeah, you're
Vanessa,
welcome.
for such an insightful conversation.
Yeah, you're
Appreciate
welcome.
it.
Thank you guys for coming. I'm so glad you were here. Sorry for the technical issues, and I'm glad you stuck around.
So thank you for attending this session with Vanessa Tillmans. You can continue the conversation in the chat or on social media using hashtag WPA11Y and hashtag WPAD2025. We also appreciate it if you go to 2025.wpaccessibility.day/feedback to provide anonymous feedback for our speakers on their presentation. You can enter to win a t-shirt while you're there. So stay tuned for James Wankin on why accessibility matters from a blind or visually impaired perspective, who is up next at 10 p.m. UTC. And while you're waiting, don't forget to visit our sponsors pages to grab virtual swag and enter for a chance to win great prizes. See you right after the break. Bye.